Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Hello and welcome to the Mineral Rights Podcast. I'm your host, Matt Sands, and I'm joined by my co-host, Justin Williams, and we're here to help you make the most of your minerals and royalties. And we're going to talk today about lease washouts and what they are, who it affects, what you can do to protect yourself in that situation. So this is an interesting topic, Justin, that you hear there's a little bit of controversy, and depending on which state, whether or not the courts will allow a company to wash out an oil and gas lease. And if this is a new term to you, then we'll dive into exactly what a lease washout is and all of that stuff. But, certainly an interesting topic, Justin.
It is, Matt. And, I've always heard of oil and gas companies releasing you, but I've never heard of the term washout. And so it's interesting. This is kind of taken in a viewpoint from the operator side and why they may or may not want to do this. But as the lease holder, you just kind of see this release. And I've only seen them in the county records. I've never actually received one.
Yeah, like Justin mentioned, there's an opportunity if you're the mineral owner, a well gets plugged, the lease expires, the operator will file what's called a release. And that's just releasing the acreage and saying, okay, we don't own a lease anymore on this. It's open. Anyone else wants to come in, you can lease that acreage. And so that will be recorded with the county, like Justin mentioned. It's not always required. So it's sort of an implicit situation. If all of the wells on an oil and gas lease get plugged and abandoned, there's no more production, that lease would have terminated. And that's kind of goes without saying, but it's also sort of in the mineral owner's best interest, especially if you want to lease that acreage again, that you have a release that's filed. And so you can request that and you'll be able to file it with the county. But what we're going to talk about is in that situation where the oil and gas lease terminates and where there are other leasehold interest owners. And so what we're going to talk about today primarily pertains to the leasehold interest. So if you're a mineral owner or the owner of a non-participating royalty interest that are tied to the mineral estate, first of all, let me just say that those run with the land. And so generally speaking, if you own those, then whether or not there's an oil and gas lease there, you have the executive right on that land that you can grant an oil and gas lease, get the lease bonus. And then if you have the royalty right, then you get paid the royalties for any production of oil and gas. And so that is in perpetuity. It goes with the land for the mineral and royalty owner. So if operator A lets an oil and gas lease expire, whether it's them or another company that goes in and releases, in other words, gets a new lease, not to be confused with releasing, in terms of expiring or terminating a lease. But if a new lease is signed, then you're still able to receive those royalty payments. But Justin, let's dive in a little bit more into what we mean when we say an oil and gas lease washout. And, let's talk about what that is and what the significance is in the industry.
Totally. And let's set the stage here. So a leasehold interest grants the leasee the right to drill a well. And if they drill a successful well, then the owner of the majority oil and gas lease becomes the operator. Their interest is then called a working interest. And nowadays, there's multiple mineral tracts that get pulled together, forming a drilling unit. And there could be multiple companies or multiple individuals who own that oil and gas underneath. The owners of that minority share of the oil and gas leases are called non-operated working interest owners, not to be confused with the operated working interest, which is who's drilling. And they're just not responsible for the actual operation and maintenance of the wells. They're just responsible for their proportionate share of the cost of drilling and completing any wells that are drilled. And if the well is successful, then for their share of the cost of operating and maintaining those wells. And in exchange, they receive the proportional share of the revenue from the sale of any of the hydrocarbons that are produced. And Matt, most of the time when you're in this situation, you're receiving AFEs, you have agreements with the operator that outlines your rights in this. And it's something that you don't just fall into typically. There's more formality maybe than just signing the lease and receiving those checks.
Yeah, these are typically interest for people that work in the oil and gas industry. So if you're a landman and you're out there obtaining oil and gas leases, maybe on a speculative basis, you own those oil and gas leases, and then the company with the majority of the leases comes in and proposes a well, and you elect to participate. In other words, you elect to pay your proportional share of the cost of drilling and completing that well. then you're now a non-operated working interest owner. And so it's not just for somebody that is typically a bystander to the oil and gas industry. They're typically people that are active in the oil and gas industry, typically in the land and title side of things, that are out there leasing and kind of putting deals together and things like that. And they will have these non-operated working interests. And it's something where I do know of, and I have several clients that have inherited non-operated working interests that are still in effect. Maybe when their grandfather or their father was working in the oil and gas industry and either investing in these types of deals or putting these deals together, they had some wells drilled and they had a non-operated working interest, and those wells have continued to produce for 30, 40, 50 years. And these interests are still in existence. And so their heirs now own these non-operated working interests. And these people in that situation are not in the oil and gas industry. They're just everyday people doing whatever industry you name it. And they have these oil and gas interests that they've inherited from their relatives. And now they're having to figure out, okay, now I get a check every month, but I also get a bill from the operator for my share of the operating and the maintenance cost for that month. And so that kind of goes along with that non-operated working interest. It's cost bearing. In other words, you're responsible for your share of the costs. Now, another thing to keep in mind, these types of interests on the leasehold side, it can be an overriding royalty interest, which is very similar to a royalty interest that you would get if you own the mineral interest. And so if you have minerals, you lease to an oil company, they drill a well, you receive a royalty payment. It's typically non-cost bearing. In other words, you don't have to pay the cost of operations or maintenance. During the leasing process, it's not uncommon for an overriding royalty interest to be granted to somebody in exchange for work that's done. Sometimes you might have a contract landman that helped lease the acreage, and there might have been a maximum royalty rate that the operator was willing to pay. And they may have come up with a contract with the landman that said, well, if you're able to get oil and gas lease at a lower royalty rate, we'll share in the difference in that royalty rate between that maximum that we were willing to pay and what you actually were able to get in the form of an overriding royalty. And you get to keep that. So when we go and drill a well, you would get the royalty that's carved out of the leasehold interest, not the mineral estate in this situation. And so in that case, the overriding royalty interest and these non-operated working interests, they run with the lease, and they terminate when the last well is plugged and abandoned on that lease. And so in the situation, the concept of a lease washout is when the operator lets those leases terminate. In other words, they plug and abandon the last remaining well or the last remaining wells on those leases. Those leases are no longer held by production. And what happens when the lease terminates is all the financial interests that go along with those leases terminate as well. And that can include the non-operated working interests and any overriding royalty interests. And a lease washout, it occurs when the operator intentionally lets the lease expire in order to start from scratch without the financial burden of those overriding royalty interests or unfavorable lease provisions or the large number of non-operated working interest owners that results in them having a lower net revenue interest. In other words, lower percentage of the revenue that's generated from those wells. And so what they look to do is, if we're going to drill new wells, we want to have better economics. And one way to do that is to start from scratch, release the minerals at better terms. Even if it's at a slightly higher lease royalty rate, it would extinguish those overriding royalty interests or maybe some of those lease provisions that were unfavorable in the original lease. And so that is one of the reasons why they look to obtain new leases, again, with that higher lease net revenue interest or lease NRI. And in theory, those new terms that they're able to negotiate for, even if they're having to pay lease bonus again, so that does cost money and that is a consideration. But in order for them to do this, they're going to benefit financially by leasing those interests again, because they'll be able to keep a larger share of the revenue generated from any future production. And again, they're not having to pay the overriding royalty interest owners, which is just a drag on the economics for those new wells if they're thinking about drilling new wells in this area. So, Justin, do you want to talk a little bit about when you might be at risk of a lease washout and some of the considerations there?
Yeah, absolutely. And this is something where if you have wells producing in a commercial quantities, this is not something where the operator is typically going to come in and they're going to cancel this lease. And generally, it would just be unfavorable if they spent the money to plug and abandon those existing wells and go out and spend the millions of dollars required to obtain new leases. It's certainly a situation where, as Matt said, it makes more financial sense to plug those wells. Maybe the lease terms are unfavorable. Maybe there's depth limitations, or maybe they're just running those current wells at a loss, and starting fresh would allow them to drill deeper and establish new production. And this is really uncommon, Matt. And like you mentioned at the beginning of the show, what typically happens is these wells just stop producing. And by virtue of them not producing anymore, those leases terminate. It seems to be much less common when the operator really goes out and makes an active effort to terminate those interests, so on and so forth.
Yeah, I think that it depends. In West Texas, we're seeing this being maybe more common just because they have the ability, and we'll talk about some of the state laws and which states are more favorable to operators in terms of allowing them to intentionally wash out a lease. But, again, just to reiterate here, I want to say if you own the mineral rights, don't worry. This is not something where the operator is going to come in and arbitrarily extinguish the lease if you have a really good producing horizontal well. And they're not going to go in and spend, in that case, probably hundreds of thousands of dollars to plug and abandon and then cause those leases to expire and then have to spend the money to go and release all that acreage and then spend the millions of dollars to go and drill the new wells into those same formations. That would make little sense for them financially. And so the financial incentive really drives them to effectively operate and maintain the existing wells and get the most out of those wells and try to make the most money in that situation. And then as any wells that have been producing for a long time, as they near the end of their economic life to where the operator is either just breaking even or maybe even losing a little money each month. And if they don't have plans in the near future to go and drill additional wells to where it makes more sense for them to keep nursing those wells along, then they may elect to plug and abandon those existing wells, and then they'll, let those leases expire and then wait. And then maybe it's not currently economic to drill additional wells in that area. It could change in the future, but it is possible that there is oil and gas there. It's just not economic to drill at the current prices. So a lot that goes into the considerations as to what they want to do in an area. But a lease that is held by production is very valuable to the operator because any future reserves, especially if there is undeveloped acreage in an existing formation that they're producing from, that's sitting on their balance sheet as proved reserves, which has a significant amount of value with it. And so by plugging and abandoning those wells, they're also writing off those reserves. They're basically letting those go away. So there's strong financial incentives for the operators to continue to operate wells that are economic to do so and to drill any additional wells if it is economic to do so in the future. So a lease washout is a situation where the economic incentives are directing the operator to want to extinguish the existing lease to obtain new leases that are more favorable to them economically so that they can go and drill new wells and not have those burdens of a lot of overriding royalty interest or a lot of minority non-operated working interest partners they have to deal with. And that also they have to pay their proportional share. But a lot of times what happens is if you have these non-operated working interest partners, they've inherited these interests. A lot of those are not going to participate in the drilling of a new well anyway. And then they're having to carry that interest and deal with the whole accounting of, the penalties and all of that. So it's easier for them in some cases to just say, well, let's just wash out those leases, obtain new leases at better terms to us. Then when we go and drill a new well, we can maximize that opportunity financially and make the most from that new project. Now, again, the issue arises in that situation with any of the existing leasehold interest owners, like the non-operated working interest owners or overriding royalty interest owners, because your interests get extinguished when the existing leases terminate. So that lease washout is a big concern for people that own overriding royalties and also those minority non-op interests that we want to see continue. They're still profitable, they're still making money. Maybe we're producing from an existing vertical, conventional well, but there's the prospect of a bunch of horizontal wells getting drilled. And that's why I mentioned West Texas, Justin, as being kind of an area where this has probably a higher potential to occur than in my opinion, like most places, just because Texas law favors operators' ability to intentionally wash out leases. And then there's also a lot of, I guess, unfavorable leases, maybe, or a lot of non operated working interest owners or overrides that have kind of accumulated over the years and they've had to deal with. And maybe depth limitations, to your point, Justin, if there's like a savvy mineral owner that when they leased the minerals originally put a depth restriction in, and maybe it's near now the depth of where they're looking to go, or they want to go and develop both shallow and deep, and they're going to have to lease that deeper formation anyway. Well, they could probably kill two birds with one stone if they go in and just wash out the existing lease and then go and lease it for all formations. And so could be a lot of reasons as to why an operator would want to do this, but there's definitely some concerns if you have an override or a non-operating working interest. It's something you need to be aware of.
Yeah, absolutely, Matt. You said it. And you mentioned the states, and this really varies by state, how the state handles it. As you mentioned, Texas is kind of on the extreme end of being for operators. And unfortunately, for overriding royalty interest and non-operating working interest owners, it's perfectly legal in Texas for operators to intentionally wash out the lease burdens, such as those overrides and the working interest. And that's because the courts have said there's no fiduciary duty that exists between the operator and the other minority interest owners. That said, there is some new legislation that just passed in Texas that protects overriding royalty interest owners under a bad faith washout. And we'll talk about that a little bit. But Matt, there's also language that you can put into the lease. And one of the common strategies that you see with overriding royalty interest includes lease language that basically says that the lease should be assigned to and attached to any extensions, modifications, ratifications, amendments, so on and so forth of this lease, covering all or any of the portions of the land. And that's, Matt, in an attempt to try to protect that overriding royalty in the event that the lease changed. And the new legislation is basically setting up the framework so that there is a course of action for overriding royalty interest owners who believe that the washout was done in bad faith. And how it's defining bad faith means that it's the conscious taking of action for the purpose of washing out all or part of specifically the overriding royalty interest, Matt. And that's kind of ambiguous, but interesting to see that they're putting this framework in place so that it can be brought before a judge.
Yeah, you're exactly right. And one thing I want to mention before we talk specifics about that new House Bill 450 that was passed in Texas that provides some protection for overriding royalty interest owners is that the anti-washout provisions that Justin mentioned, that's the language that says that any of those overriding royalty interests basically shall be applicable and attached to any future versions of that lease, whether it's an amendment, a ratification, modification, extension, a renewal, a top lease, and even a new lease of basically the same terms. Then it's trying to protect your interest from an overriding royalty standpoint, or potentially a non-operating working interest owner saying that if the person that is being assigned that lease, so like the operator in this case, basically terminates the previous lease or lets the lease expire, and then within a certain period of time, it has to be a finite period of time, you could put in there maybe 1 year after the expiration or termination of such lease, that the intent or the hope would be that you would be able to enforce an override on that new lease. Now, it depends on the state. Like Justin said, Texas, it's perfectly legal for operators to intentionally wash out those lease burdens. And even having that language in place in Texas, you're probably not going to get the override in that new lease situation. But in other states, it could be very helpful. Like Oklahoma, I know, is one of the states that on the other extreme actually has some protections in place that establishes that in that extension or renewal clause in an assignment that creates an overriding royalty interest, creates a fiduciary duty between the parties involved. And there was a couple of cases that have been heard that kind of upheld this. And so in that situation, as long as you have that extension or renewal clause in the assignment document, and that the overriding royalty interest was an important part of the consideration received in the assignment, so part of the financial consideration that was given in exchange for that lease and for that assigning of that lease, then that is something where you could potentially be protected. Now, in Texas in particular, they're very picky, and I'd say most states are picky about this whole concept of perpetuity and something like a lease extending into perpetuity just by saying, well, no, if any future leases get signed, we have an override in that. They're going to say, yeah, right, nice try. That violates the laws on perpetuities. And so we're not going to enforce it. And so that's why having a finite term in there and saying that, any new leases that are in effect within a period of 1 year, 2 years after the expiration or termination of the existing lease, that's why you have to put a very finite period of time in there. And you could talk to your attorney, of course, if you're in a situation where you're concerned about a lease washout and you need to get some legal advice. This shouldn't be construed as legal advice or any financial advice. This is just being shared for informational purposes only about what a washout is, how some states treat it, and what some different options are. But you definitely need to get help from an attorney if you're in this situation of dealing with a lease washout and you're trying to fight it. So with that, Justin, do you want to talk a little bit more about this Texas Act that was just passed this year about the different conditions that have to be in place when you could be entitled to some remedy, whatever that is, if you can prove these following things? You want to talk about what those things are?
Yep, absolutely. So a person may bring a case of action for a bad faith washout of the person's overriding royalty interest in oil and gas lease. And the person's entitled to that remedy, as you mentioned, Matt, if they meet the provisions. And number one is the person owned or had a legal right to the overriding royalty interest. Defendant had control over the oil and gas lease burdened by the overriding royalty interest. The defendant caused a washout of the person's overriding royalty interest, and the defendant acted in bad faith by knowingly or intentionally causing the washout. And Matt, this still feels pretty ambiguous because you're certainly setting the stage to have to prove that they did this in bad faith. And then the question becomes, is a financial motive of it not being profitable anymore, is that bad faith?
Exactly. Yeah, this is where I think this one is probably going to get challenged. It maybe not be as powerful as it may seem at first glance. I think, to your point, it's just saying, well, yeah, if you think that there was bad faith, you can go to court and sue the person. And it does give a few conditions that if you meet these conditions and you bring action against the defendant in this situation in a court, then you could recover damages and perhaps get some effect on the new lease and getting that same override in place in the new lease. But it sort of seems to me, I agree, that you're really relying on the courts and their interpretation of previous case law plus this new provision or new rule. And ultimately, there's no fiduciary duty. It doesn't affect the fiduciary duty between the operator and the overriding royalty interest owner. And so to the extent that they're still acting in their best financial interest, it may be that you're out of luck in that situation. But it'll be interesting to see if this gets tested in the courts. I'm sure it will in short order. And then, when that gets tested in the courts and we have a few of these cases that they go after an operator with these new bad faith provisions, and let's see what happens. But yeah, I'm kind of skeptical as well in terms of this being super strong and enforcing operators and overriding royalty interest owners and getting an override in the new leases. But we'll see.
You said it, Matt. And I thought, too, it was a little bit strange. So the limitation on a filing action, a person must bring an action under this chapter not later than the second anniversary of the date the person obtained actual knowledge that the washout occurred. So that's a pretty short duration, Matt. This is something that, if this happened many years ago and you inherited this, it's probably going to leave you with not a whole lot. It's more of you have to kind of be on top of it and start this if it's going to be upheld in court. So interesting to see. And as you mentioned, Matt, Oklahoma is completely on the other side of this. And that Oklahoma will establish the presence of an extension or renewal clause and as an assignment that creates that overriding royalty interest. And it specifies that actually creates that fiduciary duty between the parties involved. And that, Matt, it pretty much saying that if this was the same lease, same terms in those ways, and that extension or renewal clause is there, that the courts are likely going to uphold that. And it looks like it has been followed in subsequent cases since it was established with the case of Pross versus Hughes. And interesting that Oklahoma takes it that way. So it's certainly a powerful clause in Oklahoma.
Yeah, Oklahoma seems to be maybe the best state if you have an overriding royalty interest from that standpoint. And there's maybe a little bit more in terms of protections that are in place and in case law that sort of helps, with the renewal and extension clause. I think that's the key component is as long as you have that renewal and extension clause and that holds some weight. If you don't, then I don't know that that's going to help you a whole lot. So, but yeah, definitely interesting to see that it's really very state specific. So, I think that's where it really becomes even more critical to get help from an attorney that's in your state that, can help you figure out what your options are in the state that you own those overriding royalty interests or those non-operated working interests, because that's going to dictate what your rights are. So one thing also that I'd like to mention before we wrap up, if you own a non-operated working interest, you may have also some additional options. And the first being that the Joint Operating Agreement, or JOA, is the document that dictates the rights and responsibilities of the operator and the non-operated partners. And there might be anti-washout provisions in that JOA. So you would need to read your JOA and see exactly what the terms are, and that would dictate what your rights and responsibilities are when it comes to plugging and abandoning wells. And the other side of things is if the operator proposes to plug and abandon wells that will cause the lease to terminate when those wells are plugged, you're going to get an AFE with the estimated cost of the plugging and abandonment and your share of that. And by virtue, if you do not respond, they're going to take that as acceptance and they're going to proceed with plugging and abandoning, and they'll send you an invoice with your share of those costs. Otherwise, they may give you the ability to object and to take over the operation of those wells. So that may be your only remedy if you own a non-operated working interest in those wells would be say, hey, no, I believe there's additional reserves that can be produced. Maybe they've been trickling along at, a few tens of barrels a month or whatever, and they're still maybe barely breaking even. Maybe you have been approached by other entities that are looking to invest in that area and want to drill some deeper horizontal wells and are looking to buy out your non-operated working interest and propose wells. And this may give you an opportunity to put a deal together. Now you'd have to definitely get help from an attorney if you're in this situation, because this can get very tricky and you'd be taking on a lot of liability potentially, both environmental liability. And then the other thing is the JOA may dictate what you would owe the other partners in terms of the value with the equipment and wells and pipe and all the stuff that is there. And now granted, it's probably been depreciated to almost zero at this point, but whatever the salvage value of that equipment or the stuff that's there, the physical and tangible stuff that is associated with those wells, you would have to pay the other, the operator and the other non-op partners the value of that in order to buy them out, basically. So it can get pretty complicated, can be pretty interesting. There's a lot of value with non-operated working interests. Maybe it's an old vertical well that's holding some leases and you're in West Texas and there's in the middle of where they're drilling Sprayberry and Wolf Camp, and it's just a matter of time before that formation gets developed in your acreage, and it could present an opportunity, but it is also a very high risk in terms of like when we talk about risk versus reward spectrum, that gets into the highest risk side of things. So just be very aware of that, but it could be also worth pursuing if otherwise you would basically have to pay the P&A invoice and then you're out the value of that leasehold interest that maybe had some significant value prior to that proposal. So something to consider. And it would be something I think you'd have to have the agreement in place with whoever is going to drill those wells, and so you could assign it to them right away. I wouldn't think you'd want to be in the middle necessarily of operating those. Of course, each person's situation is different, but in general, if you want to just extract the economic value from that, it would be more of a brokering the deal and then, stepping aside, but, something to consider as well.
Yeah, you said it. And, it's interesting to kind of look at it from the operator perspective. As a mineral owner, this is something that it can kind of pass you by. It doesn't have a whole lot of effect on you. But for overriding royalty interest owners, that hurts when those leases are released.
Yeah, big time, especially if, again, there's that potential for future wells to get drilled on that acreage. It's being held by a marginal vertical well, and they're kind of hoping that those nice horizontal wells would get drilled. And then in this situation, if they wash out that lease, then all of that value goes away. You basically are left with nothing. So definitely something important to know about if you own an overriding royalty interest. And then again, if you're a mineral and royalty owner, nothing to worry about. Again, with capitalism in general, we have strong financial incentives for companies to do what's in the best interest for them financially, which by virtue of that, as a royalty interest owner, you benefit as well by getting paid royalty for any oil and gas that's produced. And so that's how they make money, is by producing oil and gas. And so it's sort of a win-win situation. And then it's a win-win even if they wash out the lease and then you get to sign a new oil and gas lease, maybe even get better terms than what you had before. If you're in an area where this is occurring, it's probably pretty hot. You could probably get a pretty sizable lease bonus. And then you still benefit from any future production from any long horizontal wells that are drilled. So it can be actually a win-win in that situation from a mineral royalty owner perspective, if you look at it kind of in the long term. Now, of course, the existing wells would get plugged and abandoned. You would stop getting royalties. If you were getting anything, probably very small amount of royalties from old vertical wells. But, the bigger picture is the upside in the future if something else gets drilled. So it just really depends on where your interests are located as to what that potential might be, if any. So again, just need to take a look at the holistic view. But again, important to know what a lease washout is. It's a not uncommon thing in the oil and gas industry. And again, depending on the state, it is something that an operator can do in some cases. And then some cases, they may not be able to do as easily if certain protections are in place to protect those overriding royalty interests. So if you have an override or a non-operated working interest, a good reminder to have copies of the original oil and gas lease and any assignment documents that granted you those interests, as well as if you have a non-operated working interest, have a copy of the operating agreement, because that'll dictate ultimately what the operator can and can't do. So anyway, hope this is helpful. And we'll have links to some resources in the show notes, which as always can be found at mineralrightspodcast.com. And until next time, thanks, Justin.
Thanks, Matt.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.